Hello, and welcome to the latest episode of Beyond the Test, Strasz Talks, Strasz Assessment Systems podcast. I'm Dr. Rory McCorkle, your host, and I'm excited for today's episode. And I'll bring out our speaker and allow him to introduce himself. I'm incredibly pleased to have Don Balasa here, and really both representing his organization, the American Association of Medical Assistants, but also his deep expertise, particularly on some of the legal sides of our profession, which we'll talk about just in a moment. So, Don, welcome to the podcast.
Thank you, Rory. I'm very happy to be here and to share the knowledge that I do have about all these issues that are relevant for credentialing bodies.
Well, thanks so much. And Don, for those watching who might not know you, could you tell us a little bit more about yourself and your role?
Yes, I again am Don Balasa. I'm the CEO and legal counsel of the American Association of Medical Assistants in Chicago. You can see some of the tall buildings behind me. And my primary responsibility is to protect the medical assistant's right to practice by monitoring proposed legislation and regulations on the state and federal level, and to make sure that they do allow medical assistants to perform tasks for which they are properly educated and credentialed. Our certifying board offers the CMA AAMA credential, the Certified Medical Assistant AAMA, and another part of my responsibilities is to protect the intellectual property rights of the CMA AAMA. With all these legal issues, I do follow matters such as these executive orders, issues regarding the Americans with Disabilities Act, any antitrust issues that arise. So never a dull moment.
Indeed not. And Don, I've been greatly appreciative of some of your analysis of some of these things that have let's say, come top of the newswire, as it were, with regard to legal issues impacting us. So thank you for that.
Thank you.
You've been in the industry for just a wee bit. So I'd love for you to tell our audience just a bit more about your career journey and what led you to testing and assessment.
Absolutely, Rory. Well, my first job out of law school was as legal counsel for the American Dental Assistants Association. And in that position, my role was once again to monitor state legislation and regulations and to make sure that dental assistants and those dental assistants who had the CDA or Certified Dental Assistant credential were able to practice the tasks for which they were educated and credentialed. And as I started doing that from state to state, I noticed how there were more and more questions from legislators and staff, and at that time, boards of dental examiners, as to whether the exam was really measuring what it purported to measure in terms of knowledge for dental assistants. I looked into that more to be able to respond to these questions, and I just got really fascinated with all the issues of testing and measurement, the concepts of validity, reliability, and everything that flowed from that. I started working for the American Association of Medical Assistants in 1985. I just got even more interested in all these issues that as testing providers, you and others are interested in. So that brought me to my present day situation with the American Association of Medical Assistants. I've served on the Public Policy Committee of the Institute for Credentialing Excellence. I've served on the National Commission for Certifying Agencies for 6 years, and I'm also interested in academic accreditation. I served on the board of the Commission on Accreditation of Allied Health Education Programs, which is also known as CAHAP, for 6 years. So I'm really fascinated with not only just testing and measurement, but also the educational aspects.
Well, and you've certainly had quite a diverse amount of exposure with all of that volunteering, not only on the educational side of the house, but also the credentialing side of the house. So certainly thank you for that. We're going to be talking today about some of the recent executive orders, and extensive conversation has occurred, of course, within our industry on the recent executive orders on diversity, equity, and inclusion. And I'll just make the note for our listeners, we're intentionally really going to focus on the ramifications of those, not so much the nature of the content or the like of those EOs, because we're not here to do political commentary. But Don has looked into these extensively and has been presenting about really the ramifications for credentialing bodies. So, Don, to start, can you share with our audience about the nature of the executive orders and how they intersect with our work in credentialing? And, in other words, how do you see these orders affecting the work that credentialing bodies perform as certified qualified individuals?
I'll be happy to do that. And I will avoid the rabbit holes of the politics, but also the intricacies of constitutional law, which is another area that is getting a lot of press these days. So I will try to keep this at an understandable level. And if I deviate from that, please let me know and I'll get back on track. So basically, we're looking at two executive orders which were issued by President Trump in January. One order is directed toward the private sector. And the bottom line there is that these orders direct the Attorney General of the United States to direct the private sector, so that's all bodies that are non-governmental, to end any illegal discrimination and preferences. Now, that word illegal is significant, and there's been a lot of controversy as to what is legal and is not legal, including DEI. And that's really the kicker that has frightened many people, and perhaps with good reason up to a point. So again, this first executive order was directed at private sector entities, which would include schools and testing bodies, and directing them to end any illegal discrimination or preferences in regard to any type of DEI, or in some cases DEIA, including accessibility activities. But there was also a second executive order that read as follows: effective immediately, all recipients of federal financial assistance. So that's important. This is directed at any entities that receive federal funding of any type. And this order directed all of these entities to cease all activities related to DEIA under their federal awards. So the first executive order related to private sector entities and directing them to stop any illegal DEI activities. And the second one addressed any entities that were receiving federal funds, and that they were to also end all types of DEIA efforts. Now, again, the extent of that is what has caused the controversy, and I will speak to the relevance for the testing and measurement sector. The first point I'd like to make is that these executive orders focus on any type of DEI programs or practices that provide any type of advantage to any of these protected categories. So when you're thinking about as a testing body or a consulting body, how far do these executive orders extend? The first test you want to apply is whether anything you're doing is giving an advantage to any individuals in the protected categories. Now, for example, some of you may be aware that we already have federal law, namely in Title VII of the Civil Rights Act of 1964, that forbids employers and any testing bodies that might be assisting employers from changing the pass rate in order to give an advantage to any of the protected categories under Title VII, which are race, nationality, sex, religion, and color. So those are the protected categories. We already have federal law that forbids any changing in pass rates to give advantages to any individuals in those protected categories. What you need to know is the areas that these executive orders do not address. These executive orders do not address any types of programs or speakers, written publications, any types of meetings that express a favorable opinion toward DEI initiatives. And that really has been the area that I found has been most concerning to testing bodies. I've received questions as to whether a testing body will get into trouble if it has an article that was written by a pro-DEI writer, or if they have something on their website that's a recording of a speaker who is advocating for DEI. I have also received questions as to whether having questions on an exam about DEI somehow will draw scrutiny from the federal authorities. What I can say is that all of those are protected by the First Amendment of the Constitution, which guarantees free speech and non-interference with the right of expression, both spoken and written. In fact, these two executive orders actually contain language that they are not intended and will not in any way restrict any of the First Amendment free speech rights of any party if it wants to express an opinion that is favorable toward DEI. So keep in mind, at a first level, a credentialing body has to look at any of its practices that might have the effect of giving any privileges or advantages to any individuals in these protected categories that I mentioned before. So keep in mind, as a first test, the difference between expressing an opinion about DEI and instituting any practices in the examination process that might be construed as giving an advantage to any individuals in these protected categories. So that would be my initial response to that, Rory.
Well, and thank you, Don. I mean, that was quite well framed. Appreciate that. I've certainly been speaking to a number of organizations as well who have reacted to these executive orders with concern in terms of how it affects their operations, and a number of them have shifted or let's say rebranded standing committees, board committees, or efforts specifically around diversity, equity, and inclusion to other terminology or other areas of focus. Based on your analysis, is that change warranted?
That's an appropriate question, and I've actually changed my mind on this just recently. These executive orders make reference to the fact, and some other documents that were issued as a result of these executive orders, other federal documents issued by the Attorney General and other federal departments, state that individuals or corporations cannot escape these orders just by changing the words. In other words, just by not using the terms DEI or A, that's not going to be a safe harbor for anyone that's subject to these orders. So initially, I thought that changing the language that a testing body uses, for example, is not really worth the effort, because the government is going to look specifically at the substance of what is going on. However, I noticed that the government was instituting searches of various organizations and corporations, both for-profit and not-for-profit, to look for key words. And some of you may be aware of that initiative by the federal government to actually see whether there's any mention of equity, inclusion, any other of these terms. So I've changed my mind, and I actually think it is a good idea for testing bodies or anyone to do a thorough search of their language and to try to use terms other than DEI because of these searches that are taking place to look at those key words. So even though changing the language is not a safe harbor, it's not going to automatically protect a testing body from any scrutiny, I actually think the better part of wisdom is to use language other than the typical DEI jargon, because that may avoid a higher degree of scrutiny if you keep the language. So that would be my current position on that it is a good idea to rebrand, to use some other language, even though, as I said, that's not a safe harbor, that's not an automatic protection against any federal initiative against your organization or your testing body. But I think it's safer to do that.
I think that's, well, first off, I appreciate you mentioning that your point of view on this has evolved, because certainly we all know that things continue to transpire, and what might be a factual analysis today is not necessarily going to be that next week. But I assume along with that, Don, going back to the undergirding, purpose of such committees or such efforts, and doing evaluation of that in combination with organizational counsel and one's governance would also be a wise move at this stage, if I may so presume.
Yes, your presumption is correct, Rory. And I do think that it would be a good idea to not only look at your policies, anything in writing, and to try to eliminate or change some of the key words when possible. In some instances, it may not always be possible, but whenever possible, I think that is a prudent step. But even looking at any types of committees that a testing body may have created, and to look at the names of those committees, to reframe them, rephrase the title in order to avoid scrutiny. So yes, I do think that is a good idea. And I can speak a little bit more about the concern that I've heard about some of these committees on testing bodies, volunteer committees, panels, whatever, and intentionally including certain protected categories under DEI, because that's another nuance that I think we need to talk about. May I address that now?
Yeah, I think that would be great. And just to drive on this one, I know certainly from my experience, there are a number of cases where in working with credentialing organizations, there are, with SME representation in these volunteer groups, there are represented spots that may be reserved for certain groups, and certainly would love to get your take on how the orders might impact those.
Very good. Yes. And that is a cause of concern, and justly so to some extent, whether reserving certain spots on whether it's an item writing committee or an item reviewing committee, or really any type of panel or committee, if reserving a certain percentage or number of places for individuals from one of the protected categories is going to run afoul of these executive orders, or at least draw some scrutiny. And I have a word of comfort in this regard. I believe that having certain positions earmarked for a protected category is likely not going to run afoul of these executive orders. And I say that because I come back to the basic test that I mentioned. Is there a policy or practice that is somehow giving advantages to any individuals in the protected category? And I would argue that having a certain number of percentage of individuals on a committee does not really give an advantage to any individuals, to any protected category that are mentioned in these executive orders. So I don't think it's likely that a testing body is going to get into trouble if it does specify that its item writing committee has to have at least 2 women, for example, or 2 other individuals from other protected categories. However, the caution I mentioned is that it's important that the reason for these individuals being on the committee or the panel is for a particular reason related to the mission of the testing body. So there should be a clearly articulated written reason why it's important to have certain slots for certain categories. And that should be tied to the mission of the testing body to be able to fulfill its role, its purpose of being able to test individuals and to be able to differentiate between individuals who have the knowledge, the competence, the skill, whatever, the construct, as all of you testing and measurement people like to talk about, that the testing body is attempting to measure and to make that differentiation. So I don't think that there's likelihood of being challenged by having certain numbers or percentages of individuals from a protected category, as long as you can truly articulate a reason why that would further the mission of the certifying board. But if I could add on to that, from the preliminary research I've done, and you're right, Rory, this is changing literally week by week. We've had this new tax exemption issue with Harvard and all of that. So that's a very new issue and involves yet another area of the law. But my sense is that if a testing body were to have a certain number of positions on its governing body, whatever that's called, the certifying body as a whole, that possibly could draw a little bit more scrutiny than having dedicated positions on an item writing committee or any other type of committee that relates to the technical work of certification. So I would just leave all of you with a word that if you have specific slots in your general overall governing body for individuals from a protected category, that may be drawing a little bit more scrutiny. And that's my best assessment at this point in time. Again, that could change, and I'd be happy to share any change of opinion that I have depending on current events. But that's my best assessment at this time.
No, appreciate that, Don, and specifically in making mention to whether it's a board of directors or a certification council that could cause additional concern, I think is well warranted and well taken. Well, certainly within the confines of our short podcast, we're only going to be able to hit a bit of the ramifications of these. So I wanted you to leave our listeners with kind of the best next steps for them. And certainly number one is encouraging everyone to consult with their organizational corporate counsel, what have you, and getting their take on these issues. But Don, for our listeners, what are the most important steps for them at this time as they look to process and formulate changes relevant to these executive orders?
Yes, I will address that. And as you say, Rory, it's vitally important that all actors, testing bodies, everyone have legal counsel. I would suggest review everything that's in writing, all of the policies, the procedures, any of the public-facing documents that are on the website or in candidate handbooks or any other documents. The legal counsel should have expertise in this area, in this new area. I think just about all of them who are working for testing bodies or accrediting bodies, education bodies, have by necessity developed expertise very quickly in this area. But my recommendation is that legal counsel review all written documents, both internal documents as well as external public-facing documents, and should provide legal counsel that's specific on all of those documents even to look for opportunities to change the verbiage, as we talked about a few minutes ago, to use language that may be less likely to draw scrutiny from any federal parties or any private parties that may be interested in making some sort of challenges. I think that the key point is the one that I made about the test that is very clear in both of these executive orders, namely that the government will be looking for any practices that give advantages to any of the categories, any individuals in these categories that are protected under the general DEIA rubric. And to keep in mind that if there's any type of policy or practice that gives these types of advantages, in other words, would help an individual pass the exam who is in one of these protected categories, those are the points that I think are likely to draw the greatest scrutiny from the federal authorities. But again, keep in mind the corollary to that principle, and that is that if there are matters of taking stances involving pro-DEI positions, I don't think there needs to be a radical elimination of those articles, those written statements, those presentations that may be on your website, may be given at your annual conference, anything like that. I don't think you should devote most of your efforts in trying to get rid of all of those. I think you really need to focus on the issue of whether there are practices that are giving advantages to members of these protected categories, and whether any of those advantages are really depriving others who are not in those protected categories of the opportunity to take and pass the examination. I think that would be my final word on the current status of things.
Well, really appreciate, Don, not only you sharing your wisdom here, but all the work that you've been doing over the last couple months to dive into these issues, and the presentations that you've given in other industry conference venues on this subject. I know we will be looking forward to continued updates from you as things continue to evolve throughout this year and beyond. So thank you in advance for that.
You're welcome, Rory, and I will indeed be very happy to provide those.
Well, and to our listeners, thank you very much for you taking the time from your day to listen to this week's episode. Look forward to speaking to you again in about 2 weeks when we will be posting the next episode. And until then, be well and take care.